It's leave to mention, my lord, an application, my lord, for inclusion in the list for urgent hearings, a very short application in connection with the 3436 application. I only want, my lord, a fresh direction, but for renewal of the bank guarantee. What has happened is the bank guarantee is due to expire on the 25th of July. My lord, the bank now wants 125% margin for renewal. My lord, other banks are willing to do it, my lord, for the same 100% margin. I am the West Bengal Housing Board. I just want, my lord, to transition. In the meantime, I want to approach a new bank for the bank guarantee. In the meantime, substitute the existing bank guarantee with a corporate guarantee for a very short time. Well, this is the scope of the application. If your lordship is pleased to list it, Mala, I don't think it take more than 5 minutes.
Who's on the other side?
Well, I have given notice. Oh, that's it. Sorry.
Meetings are completed.
What is the difficulty? What is the difficulty with the application?
Corporate guarantee is otherwise and it's secure. But rather they can find the entire amount to the register or something.
No.
They can furnish a fresh bank guarantee.
I'll give a fresh bank guarantee, but it will take me 2 or 3 weeks' time. That is the difficulty. I wanted to protect them in the interregnum. That is all.
Matter will be heard. That's a different thing. That's a different thing.
It's for an MSME like me, 3 crores is a huge amount, my lord.
That's a different thing, sir.
That's
a different thing. I'm only talking about the application.
Yes, with troubling your lordship only with the application.
The application has come from Delhi, my lord. These are not printed on a bond page. I'm only seeking for leave to stamp file.
Sorry, get it done in the bond page.
May I permit to mention that order has been passed by your lordship on 15th of July in a section 11 application, in the contested order. But in that order, lordship has been pleased to appoint the learned senior advocate of this honorable court as the learned arbitrator, sole arbitrator. But I am representing Union of India Enterprise. I have been specifically instructed if any retired judge is appointed, because this matter involves
That's not your prerogative, sir.
No, that is a request. I've been instructed to request this to your lordship, that because of this matter involves corrupt practice of the department also.
Whatever it is.
These are there, so
I have appointed somebody.
Yes, lordship has appointed. So I'm just bringing your lordship notice that if he can be substituted with 15th of July, nothing has happened in the meantime.
Nothing doing. I've already made an appointment. I've made it. Not going to change my.
Because we had suggested.
Your suggestion doesn't work for me, sir.
It's true.
This is my prerogative. I'll decide. Your department doesn't decide.
No, it's just because of the issue that is very serious. According to them, I was requested to mention.
Tell them to listen to what the court has to say.
I will. Grateful.
Section 34 applications, your lordship. Section 36 subsection 2, order was passed to secure, but those bank guarantees have long expired. We have got letter from the register, your lordship. It has expired on 24th.
Move an application.
2026.
Move an application for that.
Lordship, all I am seeking is to, if the 34 be listed, so that at least the direction for affidavits can be passed, so that there can be progress.
We'll see that 34. We'll see later.
Kindly.
No, sir. If you want to renew your bank guarantee, move an application.
No, I am not. Yes. I haven't furnished the bank guarantee, your lordship.
They have furnished it.
I am for the respondent in the section 34.
All right, 34 not right.
Your lordship, the bank guarantee has expired. The security has expired.
Move an application for that. If the security has expired. Yes.
One matter, I am the disputed in this matter. The learned counsel withdrew the matter on 3rd February 2026. They assured the payment, receiver payment, but they would not be paid remuneration. Receiver remuneration.
Why you were not there on that day, on 3rd February?
I was not there. Order was there. I was also be there. 3rd February, I was there.
Who's the client? Write to them, madam. These are not matters which.
I told verbally. Thereafter also.
Write to them. We'll see that. Next time when they appear, I'll mention it.
If my lord kindly
Yes.
in an application under section 34, my lord Honorable Justice Ravi Kapoor was pleased to release it from his list. So my lord, if that could
If the
be-
matter is released from his list, it will go to the Honorable Chief Justice. He will assign the matter, it will come here.
Yes.
Assignment has to be done by them, not by me.
My lord, this bench had jurisdiction that
So,
time.
madam, there's a process
Yes, sir. Yes.
that has to be followed.
But may I have your lordships kind leave to mention, my lord, item number, my lord, 330 of your lordship's monthly list. And this is a section 34 application, my lord, prior to my lord, direction for affidavits have been given. The reason for mentioning is that, my lord, I had pointed out to your lordship, my lord, counter claim of 17 crores were allowed, my lord, in work done. And my lord, the documents disclosed does not even come around to, my lord, 2 crores and not. My lord, I will not take, my lord, 10 minutes of your lordship, my lord. If your lordship kindly permits me any day, my lord, your lordship, on the face of it, my lord, there is perversity, patent illegality. And my lord, your lordship will find that there are no
34
evidence.
we'll see, sir. We'll start giving a date for 34th. We'll see that later. Yes.
Should I, my lord, come back before your lordship, my lord, next week, my lord? May I try my luck, my lord,
Not
next
next
week,
week.
my lord?
Award is of which year?
My lord, award is of, yes, my lord, I have been led by Mr. Sen, my lord. I have been led by Mr. Sen.
Yes, yes, sir.
What, my lord, is, my lord, I will not take time. I will only.
That's what he was also saying.
I will only, my lord, if your lordship feels that it will take time, your lordship can postpone it. But it is shocking to the conscience, my lord. I have prayed for X. It has been granted X plus Y, and there is not a single piece of evidence also to say that yes, X should be granted.
Who's on the other side?
My lord, someone, my lord, from Bombay, a notice has been given, my lord. Someone from Bombay had appeared, my lord, in the arbitration.
And third, my lord, we shall immediately give notice whenever your lordship says that the matter can be.
We'll see. We'll see, Mr. Wait for some time. We are trying to put a date for 34th so that we can
Very
start hearing the 34th.
All right.
I am grateful, my lord.
Instant matter to mention item number 1.
The paying at our instance, Lord. Lord, on the 14th of July, your lordship was pleased to file. Yeah, Lord, sir, we have indicated the date. His number. We have updated.
All right.
So just one thing, Lord, on the last page of your lordship's order, Lord, I think my advocate record has indicated that if the directions given that the orders in terms of prayers A2E of the
Why?
master, Lord, the difficulty is re-verification, all those reliefs are there, my lord. Without that relief, my lord, the department will again, my lord, keep it pending.
No, there's an order.
That is
How
the
can they
difficulty.
keep it pending?
My lord, this is the difficulty we face on a regular basis. I'm just indicating. I'll leave it to your lordship otherwise.
No, this won't do.
Very well, my lord.
Yeah. The rest I'll make it.
In case, my lord, we face any difficulty, we'll come back to your lordship. So great. Pen.
New motion section 29, item number 2.
Oh, it was ordered to them. Not today. Not today.
3.
Not today.
4.
Not today.
5.
Not today.
New motion section 37, item number 6.
Was my appeal from an order, my lord, appointing a surveyor, my lord, to survey, my lord, a portion of, my lord, a premier multi-storied complex in the city, where the allegation of the petitioner is that, my lord, some portion of the common areas have been encroached upon and built upon by the builder. That's, my lord, the, my lord, issue before the arbitrator. Now, my lord, the reason why I'm troubling your lordship is that, my lord, we had raised a fundamental point of, my lord, the arbitrability of the dispute. Which,
can
my
be
lord,
decided by the arbitrator, Mr. Saha.
yes. So, my lord, the learned arbitrator, that's the first thing that I'll show to your lordship, has taken note of my objection, but has not, my lord, dealt with it, but, my lord, proceeded to pass an interim order. Now, my lord, may I, before I invite your lordship's attention to that portion of the order, only, my lord, indicate, my lord, if there is, my lord, an unauthorized construction or encroachment into, my lord, common area, whatever the case may be, it relates to, my lord, promotion and development of real estate projects. My lord, there is a regulatory body for that, which is the RERA. And there is also the KMC, my lord, which has independent provisions, my lord, for dealing with these, my lord, sort of disputes. Now, my lord, a batch of, my lord, flat owners, my lord, altogether there are 80 odd flats, my lord, in the building. Batch of flat owners, my lord, long before, my lord, the commencement of this arbitration, had already approached the RERA. RERA has passed an absolutely identical order, appointing, my lord, its own surveyor. And, my lord, that has been carried in appeal, confirmed in appeal, my lord. And that work of survey has already been done. Now, my lord, at this juncture, my lord, another, my lord, surveyor, my lord, is to be appointed, my lord, in terms of this order. Now, my lord, your lordship is aware that when, my lord, there are specialized bodies, my lord, for example, my lord, the Tenancy Act, my lord, now there are specialized courts, my lord, for hearing only tenancy matters, my lord, under the West Bengal Premises Tenancy Act. So, my lord, under Vidya Drolia, my lord, altering the previous law, it has been held that these group of matters, my lord, will be excluded from the purview of arbitration. My lord, so, my lord, the first objection, my lord, which I had taken before the learned arbitrator, is that, my lord, the dispute is not arbitrable. My lord, kindly, my lord, indulge me by having the order, which is, my lord, either, my lord, from the memo of appeal, my lord, or at page 30 of the stay petition. Now, my lord, if your lordship, my lord, kindly has, my lord, internal page 21 of the order, my lord, at paragraph G, paragraph 7, subparagraph G.
Yes.
It is submitted that, my lord, the first three lines, my lord, pertain to something else. It is submitted that prayers A and B of the application cannot be passed in the absence of third party. It is submitted that paragraph 2 to 11, 21 of the petition, the claimants appellants have admitted the construction and alleged that those are wrongful. That is, my lord, their case. Now, my lord, can you see? Referring to paragraphs 14, 31 and 32 of the RERA, it is submitted that it is a special statute and the authority has wide powers. On this issue, he relied upon the following decisions. Now, my lord, the decisions, my lord, have also been given, my lord, for the proposition, my lord, that, my lord, these specialized things, my lord, specialized subjects cannot, my lord, form the subject matter of an arbitral dispute. Now, my lord, kindly come, my lord, to the learned arbitrator's findings. They start, my lord, from, my lord, internal page 22 of the judgment under the heading conclusion. My lord, paragraph 9A, fourth line from the top. The question stroke dispute that appears from the pleadings of the claimant is that the initial plan whereby 80 flats sanctioned were modified by construction of additional flats have since been let out to third parties and construction made on E-deck level. This is, my lord, the main issue, that constructions have been made on the E-deck level. So, my lord, he takes note of, my lord, the other, my lord, related issues. Then, my lord, kindly come to, my lord, subparagraph C at page 23. The core issue in the reference is whether the construction of the additional flats and construction in E-deck level in both towers are legal or valid, or whether they have been infringed in terms and conditions contained in the sublease. Then, my lord, straight away, my lord, kindly have, my lord, paragraph 11, which is the conclusion. 11A. page 25. Dr. Vikas Maiti, chartered surveyor, so and so appointed a survey who shall conduct the survey and inspection in terms of those prayers A and B of Schedule B, which is produced here. So straight away, my lord, without answering my question on arbitrability, my lord, the chartered surveyor is appointed. Now, my lord, I don't want to trouble your lordship too much with the facts. Permit me, my lord, straight away to invite your lordship, my lord, to, my lord, one or two decisions, my lord, on this issue of arbitrability. My lord, this first decision, of course, my lord, is the Vidya Rolia judgment, which is, my lord, give me Vidya Rolia. I don't have this compilation. Okay, thou copy the. Okay, Vidya Rolia ta kothay? Well, kindly don't be intimidated by the size of this. I shall not.
I am here, my lord. No one is going to get intimidated. With the size, yes. But I don't know whether your lordship knows. Mr. Shah was also of some sort. But now, my lord, yes. I have not seen that.
Kindly see the jealousy reeking from it.
Obviously, why wouldn't I? I'm going to get a copy of it.
Hey, there, copy there. My lord, I think this is the second judgment, my lord, in this compilation. My lord, the Vidya Rolia judgment. Give me the index, please. My lord, kindly have this judgment, my lord, from, my lord, page 72 of the report, internal page 72 of the report, paragraph 76. The citation, my lord, is 2021, volume 2. Yes, this is a page 1 judgment, my lord.
You have not paginated it.
Paginate koroni. That would be too much to expect. Lodger copy is not.
So, what do you want me to read?
My lord, may I hand up the judgment individually, my lord?
I think that's much
so
better.
sorry. My lord, let me hand it up individually, my lord.
Then I can have that.
I'm going to airdrop kochi.
Page 29.
My lord, it should be at other alada kore diye do.
Yes.
My lord, page 72, paragraph 76. And I'm not taking you to all the discussion. In view of the above discussion, we would like to propound the fourfold test for determining when the subject matter of a dispute in an arbitration agreement is not arbitrable. When the cause of action and the subject matter of the dispute relates to actions in rem that do not pertain to the subordinate rights in personam that arise from the rights in rem. When the cause of action and subject matter of the dispute affects third-party rights, here, my lord, we are also saying, my lord, that the flat owner, my lord, of the offending flat, my lord, has not been made a party, that do not pertain to the subordinate rights in personam that arises from the right in rem. When the cause of action and the subject matter of dispute affects third-party rights, that, my lord, I've already read, I'm sorry. When the cause of action and subject matter of the disputes relates to inalienable sovereign and public interest, then, my lord, 76 from 4. When the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statutes. My lord, here, my lord, both, my lord, the Kolkata Municipal Corporation Act and, my lord, the RERA, my lord, are mandatory in their application. My lord, that I showed to your lordship. So, my lord, 76.4. These tests are not watertight compartments. They do not dovetail or overlap, albeit when applied holistically and pragmatically will help and assist in determining and ascertaining with great degree and certainty when, as per law in India, a dispute or subject matter is non-arbitrable. Only when the answer is in the affirmative that the subject matter of the dispute would be non-arbitrable. However, the Then, my lord, Olympus superstructure has been referred to. Now, my lord, kindly straight away, my lord, have paragraph 80. In view of the aforesaid, we overrule the ratio laid down in Himangani Enterprises and hold that landlord-tenant disputes are arbitrable as Transfer of Property Act do not forbid or foreclose arbitration. However, landlord-tenant disputes covered and governed by the rent control legislation would be non-arbitrable when specific court or forum has been given exclusive jurisdiction to apply and decide special rights and obligations. Such rights and obligations can only be adjudged and enforced by the specified courts stroke forums and not through arbitration. So, my lord, there was an amendment of our Rent Act and section 42 was brought in, whereby, my lord, certain courts, my lord, of, my lord, the junior division judge, my lord, civil court junior division, were designated, my lord, as rent courts. So, my lord, in the light of that, it is held that, my lord, if, my lord, a rent control legislation comes under the TP Act, then, my lord, it would be arbitrable because there is no designated court for that. But, my lord, if I am seeking eviction under, my lord, the West Bengal Premises Control Act, my lord, then, my lord, I have to come, my lord, it's not arbitrable. Then I have to go to that court. So, my lord, my next step logically, my lord, has to be to demonstrate to your lordship that, my lord, when, my lord, I undertake the work of, my lord, promoting a developing a real estate project or a multi-storied building in the city, my lord, I do not have the liberty of doing it without the permission of the regulatory authority. So, my lord, I have to first register the building and the project, my lord, with the RERA. So that, my lord, the RERA, my lord, has an overwhelming, my lord, has an overall, my lord, regulatory power to, my lord, oversee every aspect, my lord, of the, whether it is, my lord, with regard to, my lord, the kind of fittings that are being provided or, my lord, amenities, my lord, that are to be provided. My lord, may I start, my lord, by inviting your lordship's attention to, my lord, just one or two provisions of the RERA. Give the judge a copy of the book. দিয়ে দিয়েছো?
Yes.
তুলে দাও ইয়েটা। হ্যাঁ, ঠিক আছে। ও দিয়ে দিয়েছে। My lord, kindly first have the, my lord, preamble for a moment. An act to establish the Real Estate Regulatory Authority for regulation and promotion of real estate sector and to ensure sale of plot, apartment, building as the case may be, sale of real estate project, efficient and transparent manner of the project, interest of the consumer, real estate asset sector to establish adjudicating mechanism for speedy disputes, so and so. My lord, very comprehensive. And, my lord, it's described to be the regulatory authority. My lord, just kindly take two more sections at my request. Preamble, preamble. My lord, kindly, my lord, just have my lord, section 4.
Application for registration of.
Yes. So, my lord, every project, my lord, your lordship will see, especially those projects, my lord, which come in, my lord, subsequent, my lord, to the, my lord, promulgation of the act, and even, my lord, previous projects. Kindly see, my lord, may I start from paragraph 3?
Yes.
Prior registration of real estate project with real estate regulatory authority, no promoter shall advertise, even advertisement is barred, shall advertise, market, book, sell or offer for sale, invite purchasers, so and so, as the case may be, in any real estate project without registering the real estate project with the RERA. Then, my lord, kindly have, my lord, 4 applications for registration of real estate projects. My lord, I am not, my lord, taking your lordship, my lord, into it, and kindly then, my lord, take section 7. Revocation of registration. Authority may, on receipt of complaint suo motu in this behalf, recommend. So, my lord, all kinds of power to, my lord, oversee, and then, my lord, to set the wrong right. My lord, kindly also have, my lord, the functions, my lord, of the regulatory authority at section 34. Functions of the authority. The functions of the authority shall include, my lord, kindly take F, to ensure compliance of the obligations cast upon the promoter, the allottee, real estate agent under this act and the rules thereunder. Then G, to ensure compliance of his regulations made in exercise of his powers under the act. Then, my lord, to perform such other functions. So, my lord, your lordship will see. And, my lord, lastly, my lord, just one more section, 2 more sections. Kindly just take 37 and 38. Power to issue directions is 37. And, my lord, 38, kindly see, impose penalty or interest for any contravention. And, my lord, so, my lord, kindly see, comprehensive legislation which is mandatory in nature. No promoter, my lord, can, my lord, establish a real estate project without first obtaining registration. And, my lord, the scope is, my lord, that, my lord, all regulatory affairs have to go there. Now, my lord, kindly, my lord, read this along with, my lord, the Kolkata Municipal Corporation Act. My lord, kindly have, my lord, section 401 capital A. My lord, kindly have it from 40. My lord, kindly have it from 400. My lord. Order of demolition and stoppage of building and works in certain cases and appeal, where erection of a building or execution of any work has been commenced or has been carried out or has been completed without or contrary to the sanction. So, my lord, that's what they're saying, that you've obtained sanction for X, you've encroached into the common area, and therefore you have acted foul, my lord, of provisions, my lord, of the RERA and my lord. So, kindly see, this is, my lord, squarely governed by section 400. Then, my lord, 401, that, my lord, in all such cases, my lord, the KMC can, my lord, order stoppage, my lord, of the work. And, my lord, 401A, construction of building in contravention of the provisions of the Act or the rules made thereunder. Notwithstanding anything contained in the Act or rules for the time being in force, any person responsible so and so to construct or attempts to construct any new building, add any floors, rules made thereunder, endangers so and so, any property of the corporation so and so, my lord, imprisonment, etc. Now, my lord, I'll show to your lordship, but my lord, that's on the merits. I really don't want to transgress there. But, my lord, just for your lordship's information, my lord, the additional flat which has been built is, my lord, contrary to the expectation, my lord, of my learned friend. Upon the sanction of the KMC, duly sanctioned, they watched that flat come up. At that time, there was no dispute. Once it is ready, once it is sold, once a third party is in occupation, my lord, no, you are not allowed to do it. They make a name, they, my lord, approach the KMC. KMC inspected and found nothing wrong. Till today, my lord, the permission subsists. my lord, one of the things again, my lord, which transgresses into the merits, and therefore I will not go into it elaborately, is to show to your lordship, my lord, at least, my lord, 15 to 20 proceedings have been filed against me. Every morning they get up and, my lord, they either file an FIR against me, or, my lord, arbitration, or go to the RERA every morning. Now, my lord, I have made a list, but then again, that is on the merits. So, my lord, I am, my lord, so far as this particular point is concerned, my lord, I have shown to your lordship, my lord, the two provisions of, my lord, the statute, my lord, two statutes. One is the KMC Act, one is the RERA, my lord, which are specialized statutes for this. And, my lord, Vidya Drolia, my lord, is quite clear that if there's a specialized statute, my lord, then it's outside the purview of arbitration. Now, my lord, kindly, my lord, I have also shown your lordship the impugned order, where, my lord, I've invited, my lord, the attention of the learned arbitrator, my lord, to the fact, my lord, that RERA disputes are there. And, my lord, he doesn't even, my lord, transgress into that territory. My lord, just on this point, allow me to, my lord, just leave your lordship with two judgments which are directly on the RERA issue. Vidya Drolia, my lord, is on a separate issue. My lord, these are persuasive in nature, my lord, because they're, my lord, of other high courts. First show the Madras. First show the Madras. My lord, 2021 SCC Online Madras, single judge. Is it paginated or not? Oh.
Yes, yes.
এটা তো দেখা কপি দিয়েছিস তুই?
Single judge Madras.
Yes, my lord, it's persuasive. My lord. আমি তোকে আমারটা দিয়ে দিচ্ছি দেখি। My lord, citation is, my lord, 2021 SCC Online Madras 16554. My lord, paragraph 27 straight away, my lord. I don't want to trouble your lordship unnecessarily. My lord, it relies, my lord, on their role here. 27. It is already found that if a special statute creates a special right or liability and provides for determination of each right and liability for the specified court or public forum so constituted, and whether the remedies beyond the ordinary domain of civil courts are prescribed, the answer is in the affirmative. The dispute is not arbitrable. It is the contention of the learned counsel for the respondent that disputes between the parties squarely covered by the Real Estate Regulatory Development Act 2016. Perusal of the Act shows that this Act provides for registration, defines the functions of the promoter, defines the rights of the allottees, Real Estate Regulatory Authority is established, powers are defined, tribunal is established, powers are defined, provisions for imposing penalty and offences are committed. Then, my lord, 29. The statement of objects and reasons shows that this act is enacted for establishing the Real Estate Regulatory Authority for regulation and promotion of real estate sector, and to ensure sale of plot, building, or apartment or building, as the case may be, in an efficient and transparent manner, and to protect the interest of consumers in real estate sector, and to establish real estate appellate tribunal to hear the appeals from these decisions, directions, or orders of the Real Estate Regulatory Authority. It is to ensure greater accountability towards consumers, would significantly reduce frauds and delays, and also current high transaction cost. Then, 30. Thus, the Act has provided for registration of real estate project and real estate agents, definitions and functions and duties of promoters, rights and allottees, establishment of real estate authority, defining their functions, powers, and importantly, providing for penalties of offences committed under the Act. Sections 59 to 69 of the RERA deals with offences, penalties, adjudication. Section 70 deals with compounding of offences. Last paragraph is 31. Therefore, considering the nature of dispute involved in this case, between the petitioner and the respondents that the arbitration agreement is one-sided agreement giving no option to the respondent in the choice of appointment of arbitrator. The dispute involved in this case is covered under the RERA, and when the statute provides special provisions for dealing with disputes arises under the Act and those remedies cannot be granted by the arbitrator, this court is of the concerned view that the dispute between the parties in this case is not arbitrable. This is Madras. And I'll leave your lordship with another short decision of Bombay, which is also persuasive.
Page.
Page follow. Page 269, your lordship will have. Rashmi Realty. No, so you just give the page number there.
I've got it. 269.
269. I'm grateful. If your lordship will kindly have this from internal page 5 of the report. At the top, kindly see the word paragraph Roman 6. Your lordship will kindly see REDA is discussed. Sections are discussed, I'm not leading your lordship through it. Page 5, paragraph Roman 6 at the top. Then, the same page, capital Roman V, submissions of Mr. Damle, amicus curiae in this matter, was recorded. He points out that the objects and reasons of RERA, he also points out preamble of the Act, points out sections 3, 8, 20, 42, 59, 72, so and so. The intention of the legislature is to protect home buyers from being abandoned if the promoter fails to finish the project or has the registration revoked. RERA authority intervenes in situations, takes appropriate steps to safeguard. RERA authority is the authority which works in an effective manner. Now, pausing here at this juncture, permit me, to indicate to your lordships that, nowhere has my learned friend ever run the case that, RERA in this case, would not have jurisdiction. Or, there is something special about this case, why, the arbitration should be entertained, and, the RERA, would not, effectively, resolve this dispute. So, this is not a case that is being run by them. As a matter of fact, all his friends, have gone to the RERA, other than, approach, other forums. Then, page 6, paragraph Roman 4, this is, important. Because, in paragraph Roman 4, your lordship finds, that the learned judge, refers to Booz Allen and Vidya Drolia. Thereafter, kindly have page 7, paragraph 9. These are the submissions, of course. He submitted that both RERA and Arbitration Acts are central acts, and therefore it is necessary to read both the enactments harmoniously. He submitted that if both enactments are read harmoniously, it can be said that RERA, being a special statute, will prevail over the arbitration clause contained in the agreement of the flat owners. Now, paragraph 12 of the report, Booz Allen is noticed. And paragraph 35, Booz Allen is quoted. The arbitral tribunals are private fora chosen voluntarily by parties to the dispute to adjudicate their disputes in places, courts and tribunals which are public fora constituted under the law of the country. Every civil or commercial dispute, either contractual, non-contractual, which can be decided by a court, is in principle capable of being adjudicated and resolved by arbitration, unless the jurisdiction of the arbitral fora tribunal is excluded either expressly or by necessary implication. Adjudication of certain categories of proceedings are reserved by legislature exclusively for public fora. Thereafter, then, kindly have, paragraph 16. where, my lord, Vidya Drolia, my lord, is extensively quoted and relied upon. Paragraph 50 and 55, my lord. Then, my lord, in paragraph 19, my lord, 17, 18, 19 all deal with Vidya Drolia. And in 19, my lord, paragraph 76 onwards, my lord, which I, my lord, place for your lordship's kind consideration. That is, my lord, noticed. And then, my lord, kindly have, my lord, paragraph, my lord, at page 23 of the report, paragraph Roman 8. Here, my lord, the learned judge, my lord, considers the RERA Act, paragraphs 24 and 25. And, my lord, the conclusion, my lord, your lordship will kindly have. My lord, from paragraph 50 onwards at page 54. It should be at page 322, my lord, running page of the compendium. 50. As held by the Supreme Court, a judgment in personam refers to a judgment against a person as distinguished from a judgment against a thing or right or status, and a judgment in rem refers to a judgment that determines the status and condition of the property, which operates directly on the property itself. In the peculiar nature of the disputes under RERA, although a dispute may be filed by an individual allottee against promoter, however, the decision will affect the plot and the building, that is the rights of other allottees, and rights of association of the allottees may also be affected. Thus, the dispute covered by RERA cannot be termed as a right in personam. Various provisions of RERA clearly show that adjudication contemplated under RERA is a matter of public policy and in the public interest, as noted here and above. It is the Chief Justice of the High Court who has been empowered to allot so RERA. Then, 52, arbitral tribunals are private fora chosen voluntarily by parties in dispute to adjudicate their disputes in place of courts and tribunals, which are the public fora constituted under law of the country. Every civil or commercial dispute, either contractual, which can be decided by a court, is in principle is capable of being adjudicated upon and resolved by arbitration. My lord, this is the discussion, and in 53, my lord, the conclusion. Settled legal position is that doctrine of election to select arbitration as a dispute resolution mechanism by mutual agreement is available only if the law accepts the existence of arbitration as an alternative remedy and freedom to choose is available. There should not be any inconsistency or repugnancy in the provisions of the mandatory law and arbitration as an alternative. Conversely, in a given case where there is repugnancy and inconsistency, the right of choice and election to arbitrate is denied. So, my lord, this is the first point, my lord, which I wanted to urge for your lordship's kind consideration. That is, my lord, the point of arbitrability. Thereafter, my lord, next, my lord, permit me to just, my lord, quickly point out, my lord, I won't take much of your time. Kindly, my lord, have the stay petition, and my lord, kindly come to page 62. My lord, this is, my lord, at page 62. Your lordship will kindly see the heading, Complaint to Regulatory Authority. And, my lord, there are, my lord, as your lordship scrolls down, my lord, page 62 and 63, your lordship finds 10 complainants who are all flat owners. Their flat numbers are mentioned. And, my lord, we've prepared a chart, my lord, which, my lord, with your lordship permission, we'll hand up. Absolutely identical. The nature of complaint, my lord, is absolutely identical, that you have wrongly constructed on the EDEC level, which you had no right to do. Now, my lord, kindly, my lord, have for a moment, my lord, page 137. My lord, including the petitioner, my lord, who is before your lordship, is also a part of the Flat Owners Association. And my lord, all these, my lord, 10 applicants, my lord, who have applied before the RERA, my lord, are also, my lord, members of the same association. Then, my lord, at page 137, your lordship has the order of the RERA, 23rd April 2025, which was, my lord, already in existence at the point in time when the impugned order was passed by the learned arbitrator. My lord, kindly have this order, my lord, at page, my lord, page 144, paragraph F. The Commissioner, Kolkata Municipal Corporation, is requested to arrange for inspection by a competent authority on the following: whether the construction of the above mentioned project so and so, including the E-deck level as well as the penthouses, has been done as per sanction plan. Details of the common area building measurement as per original sanction plan, total number of car parking areas, total number of flats. Then, my lord, G, the officers from West Bengal REDA to physically visit the site, verify locally whether if the details and documents submitted by the respondents while applying for registration of the project are being adhered to or complied with. So, my lord, your lordship will see that as on the date of passing of the impugned order, this order was already there. So, one of the points, my lord, which I will be urging for your lordship's kind consideration is, my lord, also, my lord, this aspect of, my lord, multiplicity of proceedings and, my lord, conflict of, my lord, judicial decisions. My lord, assuming, my lord, that, my lord, the commissioner appointed, my lord, by the RERA, who is, my lord, to be, my lord, in turn appointed by the KMC, which is the designated authority under the statute, returns a finding, and, my lord, the private, my lord, valuer appointed by the arbitrator returns a contrary finding. My lord, the idea has always been, my lord, to curtail, my lord, litigation and not to multiply it. So, my lord, kindly see, absolutely, my lord, the identical order. This is more elaborate in its scope. But, my lord, the schedule to the order passed by the learned arbitrator and this schedule, my lord, will, my lord, your lordship will take it from me, my lord, match, my lord, absolutely. Now, my lord, this order was, my lord, appealed from. And the appeal court's order, my lord, your lordship will just, my lord, make a note, my lord, of the appeal court's order. It's at page 146, where, my lord, the appeal court, my lord, does not, my lord, interfere with it. Does not, my lord, interfere with it. Now, my lord, just, my lord, only one further thing I want to show your lordship. My lord, at page 56.
Page?
My lord, 56. My lord, I should have said, my lord, from page 56, my lord, to page 61. My lord, I have given a list of, my lord, proceedings to demonstrate to your lordship that, my lord, this has nothing to do with, my lord, common area, encroachment, nothing. This is, my lord, just, my lord, a concerted attempt by 80 people against one person, my lord. Kindly see, my lord, the number of proceedings, all on the same issue. All on the same issue. E-deck level, area is less. Now, my lord, person is already gone, my lord, from the Kolkata Municipal Corporation, my lord, statutory authority, going to measure it. Whatever are the consequences, my lord, my lord, one way, my lord, in which, my lord, I could have, my lord, approach the problem is to come and tell your lordship, say, my lord, that I had flagged this issue before the learned arbitrator. He is not gone into it. So, my lord, your lordship will direct him to do it. But, my lord, I thought it better, my lord, to indicate. Now, my lord, kindly, my lord, for a moment, my lord, kindly have section 16, subsection 5, my lord, of the Arbitration Act. Now, my lord, it is true My lord, section 16, my lord. It is true, my lord, that I didn't make an independent application, my lord, challenging jurisdiction. But, my lord, respectfully, I don't need to do that. I just need to raise the plea. That's, my lord, what the section says. My lord, subsection 3 of section 16, my lord, is that, my lord, I shall raise the plea. Subsection 2, subsection 3, my lord, is that a plea has to be raised, which I have done. It's recorded in the order. Now, my lord, if your lordship has subsection 5, the arbitral tribunal shall decide on the plea referred to in subsection 2 and subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an award. So, my lord, I don't have to, my lord, rely upon Tayabali and, my lord, the other line of cases to show, my lord, that, my lord, point of maintainability once raised, my lord, whether, my lord, the court can proceed, my lord, without taking that into account. It's embodied in the section itself. So here, my lord, I have raised, my lord, the issue of RERA. Before him, he's taken note of that, and there's not one line, my lord, in support of that in the order. Which is, my lord, apart from anything else, my lord, completely contrary to, my lord, to section 16, subsection 5. And, my lord, what deed? Show me that. What is it? It is key that shows it. Yes. My lord, only one document, my lord, and then I'm done, my lord. My lord, I have filed a supplementary affidavit. My lord, that is affirmed, my lord, on. Give me the date of affirmation. My lord, it's an affidavit of, my lord, Mr. Kaustav Ghosh, affirmed, my lord, on 7th May 2026. My lord, in that supplementary affidavit, I have annexed, my lord, his indenture of sublease, where, my lord, his rights flow from, at page 689. 689. देखा कौन जाएगा तो मतलब 689 मतलब is the start of this indenture of sublease, which this is मतलब his the mother document of the petitioners of the claimants before the arbitration. My lord, kindly have 693 clause I. The sublessor has got approval and sanction from the Kolkata Municipal Corporation with a memo dated 6 June 2011 of a building plan number so-and-so dated 6 June 2011 for construction of the aforesaid complex on the scheduled property, and further received revised sanction plan being number so-and-so dated 5th November 2018 for construction of the said complex on the scheduled property. So, my lord, whatever is, my lord, the violation that is being complained of, my lord, was to his knowledge. It's on the basis of a sanction plan. Now, my lord, it is one thing to come and say that I have made something unsanctioned. The degree of offense, my lord, is far higher. And it is a completely different thing, my lord, to come and say that, my lord, what I have done is not in accordance with the plan, or there's a deviation. So, my lord, he is not even running the case that, my lord, what I have done, my lord, is dehorse the plan. So, my lord, all his friends, my lord, have gone to the RERA and my lord applied, said that, look, he's encroached into the EDAC area. RERA said, very well, I'm sending someone. Again, my lord, the systematic process, my lord, of harassment, my lord, continues. So, my lord, the question, my lord, that, my lord, begs your lordship very kind consideration is twofold, my lord. One, of course, is the arbitrability of the matter. The second also, my lord, is the fact whether, my lord, multiplicity of proceedings, my lord, ought to be permitted. I would have understood if this, my lord, arbitration proceeding is prior in point of time. It's the same association. Members of the same association have gone to RERA. He is not saying that, my lord, he is outside the association. My lord, these are my respectful submissions.
If I sum it up, the only thing which you're saying is that since there's a statute which governs with the kind of allegations which is being raised by them, then it should be dealt in terms of those specific statutes which are in the form of RERA in this particular case and KMCI.
That's, my lord,
right?
the sum and substance, my lord, of the trouble that I've caused for the last half an hour.
Yes. It will start, it will stretch after lunch. No, it will go, I think, because you'll take some time, right? How much time?
Take some time.
We'll
Would you
start-
like to take it on third? Another day.
Then we can hear it today.
I can start at least.
We can take it after lunch also. After lunch, what is there?
If I could today, man. Again, tomorrow, if it's
Then it will go to next week.
next week, it will have to come.
What is your,
I'll give you the
yes, give me a,
first things first, brother. Referring to section 16(5). I'm starting from there, man, because first of all, man, these points were never taken. It already filed its counter. It was already filed. After that, man, he's trying to take this point. There is a specific bar on the section. You can't take this step. And you have submitted to the jurisdiction. Kindly, man, it also should not just
so this is, before the arbitrator, this point has not been taken, the point of,
But what has he said? Before I will point out from the arbitration, from the order, he has said it will create third party, it will affect third party rights. Not that RERA is there, therefore this arbitration clause will not be applicable. And while this arbitration was initiated on a consent order passed before a division bench of this court, the division bench said that whatever it is to be governed by the arbitration proceeding. That order is clearing and binding on both of us. And this is one of the points which I'll be referring to.
where is that order?
Yes. And that is at page 665, volume 5 of the supplementary affidavit.
Volume 5.
5. Kindly see the first 4 paragraphs, the submissions recorded, then 5 minutes. In view of the fact that substantial construction has already taken place and modified building plan has not yet been depot prima facie, the applicant has right to make constructions of enter. This is a 37 agreement. This, however, is subject to question that the KMC might initiate or contemplate any such construction shall abide by the result of the arbitration. In the event the penthouse of construct is transferred and alienated or transferred, the transfer shall not be entitled to claim any equity. In the event argument is contended and held that such construction are unauthorized or not permissible or true construction of sale deeds executed in favor of the respondent. In so far as EDEC is concerned, for the government in such and such, Mr. Mitro made submissions. Then Malad kindly sees page 668. Your Lordship will find that this edict thing has been told to one person, my Lord. It is needless to mention that in the event ultimately found that such construction was beyond the agreement or the sanction plan, the modified sanction plan, as the case may be, the petition shall be entitled to seek such as may advise its arbitration following another. And accordingly, my Lord, by consent of the parties, the arbitration is appointed. And therefore, my Lord, they were well aware that this is arbitrable, and therefore no section 6 will also apply. And my Lord, as far as I understand, maybe this is a factual problem, my Lord. My Lord, I think, my Lord, this proceeding, the section 9, this proceeding was initiated prior to the raid. In 2024, yes. It was prior. Now, my Lord,
He was saying it was after.
I think he
I'll just check it
could
up.
be some instructions. And that way, I think the section 9 was in 2024. You check or no? We'll come, and obviously we will not give you a Lordship a wrong time. And we'll just what it is. So, Malak, this is my second point. That it was already decided. Now, section 16 is not there, Malak. They have submitted the jurisdiction. Now, Malak, with regard to the RERA Act, Malak, I am making the submission today, Malak. Next year I will just, Malak, when he says, Malak, there is a bar, Malak. First of all, Malak, the Bombay High Court judgment with major humility. But I do not find how that question ever even arose. The question was not an issue before that Honorable Court, but the Honorable Court proceeded. Now, Malak, another thing, Malak, though Bombay High Court has referred to section 88, section 88 of the Act, 88 of the Act, Malak, excuse me, the application of other laws not barred. The provisions of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being enforced. And then, Malak, the inconsistency. If there is inconsistency, the provision will, Malak, survive than the other inconsistent parts in other acts. But it does not bar any arbitrator or any judicial forum or any civil court from entering upon any kind of dispute resolution. And not only that, Malad, I am asking for a specific performance. There's a distinct difference, Malad. The case of Bombay High Court was on a MOU, Malad. That's the initial document on which, Malad, all the allottees are given. Therefore, Malad, it is restricted and the rights are all joined. Here, Malad, I'm put on my conveyance deed. It's a specific right given to me by him. Independent agreement, Malad.
When do you want?
Malad, next Tuesday. Your Lordship takes it on Tuesdays, Malad.
কত বলবি?
Take it on. Third, Learned Senior Counsel, Mr. Joy Sir. List for further hearing. When? Mr. Ray?
28th, Your Lordship.
28th.
Yes.
28th of July.
Deeply obliged.
One request for it. I know I should be making the right
Time.
for the but no, it could be on a bit as it is today, Madam. Position. My client shouldn't suffer.
That's a joint prayer.
No, we'll finish it. Better.
I finish it that way. Yes,
Deeply obliged. So grateful.
very good.
That's it. 28
Best of the luck. Yes, Mr.
Lord, today, my lord, I think there is examination of judgment debtor. Lord, we saw that and we requested Mr. Mitra, my lord, we'll see the report and come back tomorrow if your lordship permits.
Next week. This one matter.
Yes.
Only one matter. Only one matter.
Oh, only one minute. Lord, tomorrow, my lord.
Tomorrow it can't be next Tuesday, then it will go.
Thursday also not. Thursday possible, my lord.
Thursday, nahi na?
Well, next Tuesday, my lord. And maybe, my lord, see the registrar's report from my lord's officers after
Okay.
court.
Item 45. 42. Item number 42, my lord. That is the item.
42.
Hopefully, my lord, on that day, my lord, my learned friend will conclude.
I'm trying to.
Trying to.
No, they harass me all the time.
My lord, in other courts, my lord, when we are on the other side,
Yeah,
we say you're taking adjournments after.
I never see.
releasing matter.
He's very difficult. Very difficult. By nature, my lord, he's very difficult.
Since college, he's been doing.
He's not handing. He has been handing up photographs of me doing virtual hearings at an airport. He goes to the particular learned judge and says he argued. See, this is what he was doing. Then he finds photographs that I'm doing a matter from a car, merges it with a judgment saying it's illegal to appear from a car and cites it. They are just having your lordships will kindly protect me.
Next Tuesday, Mr. Chaudhary.
Item
Yes.
40 as well, my lord.
40 as well, Tuesday. Next Tuesday. 40, 42 both. 40, 42 next Tuesday. Call that.
Examination of judgment letters, supplementary list item number 1.
So ask him why he's not making the payment. Give the oath.
বলুন আমি শপথপূর্বক বলছি
আমি শপথ করব বলছি
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো
আমি যা বলবো সত্য বলবো
সত্য বই মিথ্যে বলবো না
সত্য বই মিথ্যা বলবো না
কোনো কথা গোপন করব না
কোনো কথা গোপন করব না
আপনার নাম
শেখ মহিদুল ইসলাম
ইংরেজিতে বানানটা বলুন
SKMOHIDULISLAM
বাবার নাম
শেখ ইউসুফ
শেখ ইউসুফ আপনার বয়স
আমার ডেট অফ বার্থ 8/11/1979 বয়স 47 প্লাস এরকম
কি করেন আপনি
আমি এমনি মিস্ত্রির কাজ করি
বাড়ির ঠিকানা বলুন সম্পূর্ণ ঠিকানা
ভিলেজ আরতি গ্রাম আরতি
আস্তে আস্তে ভিলেজ আরতি গ্রাম আরতি
পোস্ট অফিস পাটসাওড়া থানা ফরিদপুর জেলা পশ্চিম বর্ধমান
পিনকোডটা বলুন
পিনকোড 713363
713363 আপনাকে তিনটে প্রশ্ন করা হবে হ্যাঁ আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে তখন কোর্টের সামনে হাজির হবেন
ইয়েস স্যার
ইয়েস আপনি কি জানেন এই যে কথা দিয়ে কথা না রাখার ফল কি হতে পারে
কথা না দিয়ে
কথা দিলেন আপনি সেই
না
কথা
কথা দিয়ে যদি কথা না রাখা হয় সেটা তো আইনত অপরাধ হয়
আর আপনি কোর্টের সামনে কি আপনার সম্পত্তির হলফনামা দাখিল করতে চান
করতে চাই
ইয়েস
The auditor number 2 has been produced. Oath has been administered. Warrant of arrest and discharged. He undertakes to file his affidavit of asset within a period of 2 weeks. 2 weeks or 3 weeks?
My lord.
Affidavit of asset.
Yes. My lord, 23rd is the date, next date, my lord. My lord, by that date, my lord, I'll pay.
Within a period of 2 weeks. Before the next date, okay. Before the next, today is what? How can you file? Today is 21st.
Lordship kindly, then Lordship grants me
2 weeks.
2 weeks,
Within a
my lord.
period of 2 weeks. He undertakes to remain present before this court as and when required. Learned counsel for the award letter. Weeks and is granted 2 weeks time to file his affidavit of assets. Just
Wait for me.
New motion, section 11. Motion, item number 21. 40 to 41, sorry. Item number 41.
My execution, Lord, the calculators were supposed to file their affidavit of assets, so that on extension, I understand.
next week.
They will come back to me.
At least I'll pass some effective
Yes.
order.
Item number 43.
But I am the auction purchaser, my lord.
You're there,
ex-
Mr. Pandey?
Yes, I am an award holder.
There was section 9, section 36. Subsequently, receiver was appointed. He put the property on auction, and I was the highest bidder, and I have purchased that property. And I am getting resistance from the persons of the judgment debtor.
Who all are there? All the respondents are here.
I am an award holder, my lord. I think they have served the
Yes,
account.
they have been served.
They are not here. Not today. No adverse orders.
Okay. 44.
My lord, I am for the award holder, my lord. The asset has not today. We have served them, so
You know that today.
yes, we know.
45.
Not today.
46.
Not
Item
today.
number 46.
Not today.
47.
Not today.
48.
Not today.
My lord.
Not today.
I am the award holder.
They're not there.
No, I am not asking for any passing of any order. I am aware of the resolution. My lord, what went down is that we have filed a counter affidavit against their statement given. And I have served them through mail also, and I have served them by speak. Last day, he requested to serve him a hard copy, and I received their calculation sheet. So wrongly, I have sent in the mail 254 pages in 2 parts. So that is will be 154 pages.
That's your problem. Let him come next time. He'll
Yes,
point
I
it
will
out.
serve him.
49.
Lordship, I was just praying if this matter could be adjourned for 2 weeks because there was a direction for sale. Auction could not be completed, Lordship, for want of bidders.
After 2 weeks.
50. Item number 50. Item number 51.
Not today.
Monthly item number 74. Execution cases.
74, my lord, I am for the award holder in this matter also. My lord, my instruction is that, my lord, parties are trying to settle the disputes. My lord, part award has been satisfied, and my lord, the respondents and one application for substitution is also pending, filed by my client. But my instruction is, my lord, if your lordship take it up in the monthly list of September.
Not today.
That-
It can come the other side.
Now 75.
Not today.
Release new motion section 11 at now 7.
Not today.
8.
My lord, 8, my lord, I am opposing just that matter.
I wish there was somebody to oppose.
Yes. My lord, they were, my lord, on the last.
You
occasion-
wanted that commercial thing, huh?
Yes. Now,
That there are, but I think the rule itself says that it can be converted. They
Yes,
need
ma'am.
not withdraw it, they need not file.
now, my lord,
We'll see it later. This is something which I had in the course of couple of more. matters.
certainly it should be in their presence. In fact, in the first half, they were there.
That's okay. Today you know the resolution, so they're enjoying the resolution.
Now, my lord, in that event, my lord, may we come back not in the next week, a week thereafter, Lord, subject to my lord's convenience.
Not giving a date, not recording any order, not this week, after 2 weeks. Give it after 2.
After 2 weeks. Huh?
After 2 weeks.
Grateful, my lord.
9. Then
Well, I appear for the petitioner. The respondent is
The
there.
respondent, ma'am.
Well, subsequent to the filing of the Section 11 application, well, there's been a development. We have been offered with a proposal for settlement. So, well, if the matter could stand over for a fortnight, well,
Learned counsel for the parties submit that they're exploring, learned counsel for the parties submit that they're exploring a possibility of an amicable settlement. In view of the same, the parties pray for an adjournment. Let this matter be adjourned to
for a fortnight, well,
2 weeks,
Yes.
3 weeks. Give a- After 3 weeks, give a date.
after 3 weeks.
indeed. Well, in the meantime, if I may file my affidavit in reply, my lord.
Affidavit in right is taken under consideration, filed by the petitioner.
Great.
Eleven.
11 with the petition. Well, earlier, your lordship was pleased to direct me to start the HON'BLE.
Yes.
Lord, this is a small dispute, the amount. My lord, kindly, my lord, refer the dispute before the mediation. But he is appearing, he is very good lawyer for mediation purpose. So can be placed before the mediation, the disputed amount 15 lakh.
So not arbitration before,
Yes, lordship.
for arbitration or for mediation?
No, mediation.
Mediation. Learned counsel for the parties submit that they want to explore the possibility of an amicable resolution to the dispute. They pray for this matter to be sent to the mediation cell. Full stop. Let this matter be listed before the mediation cell to explore the possibilities of a settlement between the parties. List before court after 4 weeks.
Get good.
Your Lordship, in item
Well-
8, I'm for the petitioner, Your Lordship. I was on the way.
I have not passed any adverse order, did I?
No, Your Lordship, I have a reply to file, so kindly with it.
You have a reply to file?
Yes, Your Lordship.
Now 8.
Item 8 will
Exactly.
include learned counsel for the petitioner. The reply filed by the learned counsel for the petitioner is taken under court. Reply to the affidavit in opposition.
Opposition. And this copy for the other side.
Reply to the affidavit of opposition filed by the petitioner is taken under court. All right, list after 2 weeks. 2 weeks?
Yes.
3 weeks कर दो. 3 weeks. कर दो. 3 weeks.
My lord, 2 weeks were there, my lord. We can.
3 weeks.
Good.
I know 11.
11, we have
11,
referred
oh,
to mediation.
Sorry. Arjun, 4 weeks.
After 4 weeks, 11 is after 4.
12.
Well, my lord, I am for the petitioner.
Yes.
My lord.
Are we
Section
doing it
11
today or?
No, no. Today I'm ready, Lord.
Yes.
My lord, section 11 application, my lord, under the my lord, 3G, my lord, I am praying for appointment of arbitrator, my lord, National Highway Act.
Any
my lord.
dispute regarding that?
Lordship, no dispute regarding that.
Yes.
But if I may point out,
Yes.
your Lordship will kindly take the cause title. Lordship, the petitioner has made the adjudicating authority as a party respondent, the land acquisition officer. Lordship, as per my instructions, it's the National Highway Authority that ought to be the party.
That's correct.
Yes, Lordship.
You have
Lord,
to
may I
make the
cite-
NHAI a party.
My
You're
lord,
taking an up.
no, my lord, now, my lord, I have given a notice, my lord, under section 21 to the authority, my lord, that thereafter, my lord, the authority perhaps, my lord, forwarded the same, my lord, to the concerned authority, which is, my lord, page 39. So, my lord, I can only suggest one thing, my lord. If, my lord, they have no dispute with regards to the appointment of arbitrator, my lord, perhaps when the statement of claim will be filed before the arbitrator, my lord, I will file it through the correct authority, my lord. Lord, I hope my learned friend will not dispute to that.
Yes, Lordship, I am not objecting to that. Your Lordship will record that in the order that the National Highways Authority be made a party.
They should be made a party. Make the correction in the cost title, put them as a party, serve them, and you appear for NHAI.
Yeah, yes, Lordship. In this matter, at least I am appearing. I'll take
Make them a party. He's here to
Lord, that's why I'm saying, my lord, it can be resolved today itself.
party. Have to pass an order.
Yes.
Learned counsel for the petitioner seeks and is granted liberty to amend the cause title, wherein the cause title to bring in National Highway Authority of India as a party respondent to the present proceedings. The same shall be done within a period of 1 week.
Lord, by in course of today or day after, by tomorrow only, by
Within a
tomorrow.
period of 1 week, list after 2 weeks.
My lord, can I serve the copy directly upon my learned friend because he is appearing?
Lordship, upon Mr. Das. Yes, Lordship.
Whoever is the other, whoever is the standing counsel or the counsel on record,
Lordship, I am the additional government leader. It can be served on Mr. Chatterjee. I will give the details to my lord.
Yes, my lord, so that
you can accept service.
Yes, yes, he can accept service.
then my lord, it will be deeply obliged. Namtaji.
Grateful.
Thirteen.
Not today. Any matter where both the sides are here.
Item number 15 was in the last occasion. It was on the verge of settlement, my lord. They have complied also.
Who's on the other side?
Isn't also in the first half also.
He's not here now.
For the
Next
means
week,
my
next week.
application for the claimant bank.
Next week. Call out 20.
My lord, yes, sir.
Yes, tell me.
15. Miss my lord,
Just call out 13, 14 also.
14.
Not today.
15.
Present applications under section 11 was initiated by me. I had a
Good.
claim of
What
rupees
is the
40 lakhs, my lord. Subsequently, it has been settled.
Settled?
Yes, ma'am.
So you withdraw it.
My lord, it was settled. We have executed the cancellation agreement also.
Alright, so this petition you'll withdraw.
My lord, I will withdraw.
Learned counsel for the petitioner seeks to withdraw the present petition since the matter has been amicably resolved before the mediation center, full stop. The parties will be bound by the terms of settlement entered into before the learned mediator, full stop. It is clarified that in the event if the party fails to adhere to the terms of the settlement, such party shall be at liberty to invoke the jurisdiction of this court under Section 11 of the Arbitration Conciliation Act 1996 to adjudicate the dispute between the parties out of the said development agreement. With the aforesaid direction, the present petition is dismissed as withdrawn.
And now 16.
Not today.
My application other under section 11.
Not today.
That would be the same with item number 17. Though service has been effected and refused, Malad. I understand, Malad.
No adverse orders, whether refused or not refused.
So Malad, it may come in the next week, Malad, since it's great.
17.
Same.
Same. 18, sorry.
18.
Not today.
19.
19, Your Lordship, I appear on behalf of the respondents.
For the petitioner, section 11 application, he has taken one point that in a development agreement, Your Lordship, the nature of Your Lordship dispute should be commercial. And in the section 11 application, I have specifically pleaded that the user, Your Lordship, is completely Vastu, residential. I have taken, Your Lordship, the building
There's some
sanction plan for
judgment which he was
residential.
supposed to show.
Lordship.
That's what he had asked.
Yes, yes.
But you showed two judgments, one of the single
Show
bench
it
and-
to me next week.
Very well, Lordship.
If you can give me, I think Your
Yes,
Lordship,
yes, I'll
Justice
give a
Tappa
copy.
Karta's judgment and
I'll give a
Justice.
copy. I'm giving a copy right now.
Kumar. I have seen, Your Lordship, both the judgments, Your Lordship. I'll try to distinguish.
Next week then. Grateful, Lordship.
And now 20.
Lordship. Your Lordship recalls this that matter where I've taken Your Lordship's liberty to refile.
Today, sir, not
Your Lordship, just one small indulgence. I'm yet to serve the opposite party anyways. But Your Lordship, one small indulgence that this matter has the possibility of going into mediation, but only if it comes from the bench, Your Lordship.
But only if the other
Yes.
side- How will I send a matter to?
No, Your Lordship, only if it comes for Your Lordship the next time it's listed. I can understand.
The other side has to be there. He has to. Give
I
a
can
consent.
understand Your Lordship's position as well. Grateful.
Mediation can't be unilateral. No?
No, of course, Your Lordship. Thank you.
Rest of the matter later. Any other matters where both the sides are here? I don't see that. Hardly anybody.